This position need not impede the committee's inquiry. It does not prevent Scottish Government witnesses from explaining in detail to the committee in their evidence what the Scottish Government's legal position was at various points. The Lord Advocate indicated in his submission to the committee, and I repeat this intention here, that the Scottish Government will be happy to give a full account of its legal position at different points in time in relation to areas of interest to the committee. That was the Deputy First Minister in his letter of 14th August. The committee therefore expects a full account today, and where legal privilege is asserted on any details, we would appreciate the grounds for this to be set out clearly. With that, may I welcome Paul Cackette, former Director of Legal Services, Scottish Government. And I begin by inviting Mr Cackette to take the oath. If you would raise your right hand, please, Mr Cackette, and repeat after me. I swear by Almighty God.
I swear by Almighty God.
That I will tell the truth, the whole truth, and nothing but the truth.
That I will tell the truth, the whole truth, and nothing but the truth.
Thank you. I now invite Mr Cackette to make a brief opening statement.
Yes,
Mr
thank
Cackette.
you. And good morning, Convener. Good morning, committee members. Since 26 March 2020, I've been redeployed on COVID-related work, initially on organisational readiness and then on temporary promotion as Director PPE from 10th April to 26 June, and since 26 June as Director Outbreak Management. My current formal role is the Chief Planning Reporter, which is a post I've held since August 2016, after 7 years as Deputy Solicitor in SGLD. I was appointed as Director of Legal Services as Head of SGLD on an interim basis on the 8th of May 2018 and held that post until 14th June 2019. SGLDs sit within the DG Constitution and External Affairs family within the Scottish Government. The Director-General there is and was at the relevant time Ken Thompson. In that period, I was responsible as Head of SGLD to the law officers for all the legal advice given at that time and for the management of the Directorate-related matters, and thus I was responsible for all SGLD advice in that period for the running of SGLD and for its financial and people management responsibilities. And obviously I'll try to answer all questions as I can in relation to those aspects and other questions of the committee. You've indicated, Convener, already the position as far as LPP, which I needn't repeat. I'll endeavour to answer detailed questions on the conduct of litigation as well as I can from my own recollection and the emails retained by me from that period, subject to that. But I obviously wasn't directly involved in every single aspect of the case, nor copied into every email. Where I'm unable to provide a sufficiently detailed answer for the committee, and where that can be done without breaching LPP, answers will be provided in writing in a way consistent with the letter from the Deputy First Minister of 14th October. And I'm very happy to return to the committee if it feels it would be helpful for me to do so, if any further questions arise from that. Lastly, I should declare that since 2012, I've been the Scottish Government nominated officer for compliance with the Civil Service Code. Thank you.
Thank you very much, Mr Cackette. Now move to committee members who wish to ask questions. Now go first to Alistair Allen, who's joining us remotely. Alistair Allen.
Thank you, Convener. I wonder if you could say a bit more, Mr Cackette, please, firstly about the extent of the role that you had personally in decision-making around this case, and particularly to whom you reported in making those decisions.
Catch the very last bit of that question, particularly on the...
Can I ask you what your role was in making decisions around this case and to whom you reported?
Okay, right, thank you. Yes, my role, as I said in my opening statement, was as was senior lawyer within the legal directorate, and I had a general overseeing role in relation to this case to ensure that the advice given to the Permanent Secretary initially in relation to the operation of the procedure from when I was appointed until the final decision was made was to the highest professional quality, and then after the decision was reached by the Permanent Secretary and then matters were referred consistent with the procedure to the to the First Minister and other ministers, and then was responsible for providing advice to the course of the judicial review right up until its conclusion. That involved the coordination of a number of areas of SGLD advice, partly and primarily in relation to the operation of the procedure and how it applied in the particular circumstances, but also in the management of the litigation itself. We have a number of divisions within SGLD with different responsibilities, some subject matter responsibilities, and there was one division advising on matters relating to employment law, and therefore they had the kind of the overarching responsibility, if you like, the SGLD policy lead, and they worked with the litigation team, who became involved, but actually only became involved because of the confidentiality of the issues prior to that. They only became involved at the stage when the judicial review was intimated as being about to be served. So it was basically those two divisions were involved, and my role was to ensure a coordination and the confidence from me reporting to the Lord Advocate on the advice, on the substance, and on the handling and running of the judicial review.
Can I ask in that case if you're able to make any kind of comparison with other judicial reviews? I'm aware that the government has to deal typically with many judicial reviews. Can I ask, are you able to make any comparison as to whether the spend on this case was typical or atypical?
I suppose there's two differences from what you might regard as a typical judicial review. There was no doubt that my role as being the director involved a greater level of involvement in this than a kind of typical run-of-the-mill judicial review. It's not unique because sometimes the director takes a close involvement in that. So it was different in that respect. In terms of expenditure, from the legal directorate's perspective, I think it's fair to say that we did involve probably a larger number of lawyers were involved in different aspects because of its multifaceted nature than most judicial reviews. Our costs generally were again not wholly untypical in the sense that we'd instructed senior counsel. We do instruct senior counsel obviously for the most important of cases, including those that go to the Supreme Court, but I would say the majority of litigation that the government conducts is conducted by our panel of junior counsel who deal with, as I say, most cases, and that involves, obviously, because it's one counsel rather than two, a lower amount of expenditure. So from my point of view, it was more expensive, but given the profile of the case, not standing out any more than, say, a Supreme Court case would be.
And finally, can I ask, I appreciate it's difficult to make comparisons for the reasons you've given, but given the number of cases of judicial review that the government deals with, how typical or atypical is it for a case to be conceded? And can you say a bit more about that, the comparisons that might be made with other cases on that?
Yeah. The government actually happily, for the SG, actually loses a relatively small number of cases. The vast majority are won, and certainly the consequences of losing are very significant, as can be seen, well, not only obviously here, but in other cases where the implications are significant. In terms of numbers of cases that we would concede in advance, again, it's pretty rare. But I would say that, as I said in my opening statement, that my role, not as a lawyer, but is as Chief Planning Reporter, and in the planning context is one that I'm kind of most familiar with. We have conceded cases. I wouldn't like to put a percentage figure on it. And indeed, I was conscious of one case 3 years ago where I looked at the decision we'd made and I decided, even though it hadn't been appealed and wasn't due to be appealed, it was unsustainable because the reporter had gone so wrong and offered to the other side, if they appealed, we wouldn't oppose that. and it will be set aside with expenses against us. So in the planning context, I'm not trying to suggest planning is any worse than anywhere else. We do concede cases from time to time because we look at it, and we will look at, as in my experience, specifically as in the planning context. And we quite often, we have sometimes looked at cases and said this can't be supported, and we'd concede a case in those circumstances.
Thank you, Convener.
Thank you, Mr Allen. Can I move now to Margaret Mitchell?
Thank you, Convener, and good morning, Mr Cackette. Were you aware the former First Minister had suggested arbitration as a means to settle competency and legality of the procedure?
I'm looking to the convener here. I think I could answer that question in light of some earlier issues in relation to privilege, and she's nodding, so I'm taking that's a yes. So the answer is yes, I was.
Okay. And who made you aware of this, and did your department, were they involved in discussions about the decision to reject arbitration?
Yes, I became aware of this proposal about arbitration from lawyer-to-lawyer correspondence, which was around June 2018. I came into post in May 8, 2018, and I knew there had been a previous suggestion of mediation for my time, and then the suggestion of arbitration came, as I remember, around June.
And were you involved in discussions to
yes, I was.
reject on the basis of?
I was involved in my discussion on the basis as legal advisor at that point, but it was also something that I was aware of in terms of the kind of the pros and cons of arbitration as a potential way forward from a previous policy job that I'd done.
But why didn't you think it was suitable and should be rejected in the judicial review? It was about competency and legality of the procedure.
Well, I'm not sure I can answer the question about the I'll be to answer the question about the legal advice given, but what I can set out is the Scottish Government position, the policy position, if you like, in relation to the rejection of arbitration, if that be helpful.
So you weren't asked your view and you didn't proffer a view?
The Directorate gave a view.
And that was on what basis? To reject this on what basis?
It was rejected on a range of reasons. The view that we'd taken was that at a general level, arbitration was something that could be open to dispute resolution and resolution of, if you like, technical or legal issues that were outstanding, where the parties had a desire and an incentive for quick resolution of an issue of a technical nature, but it is not generally regarded as being an appropriate means of resolving a dispute where there is a significant degree of factual disagreement in relation to particular harassment type.
Can I stop you there?
Of course.
Arbitration had nothing to do with the substantive complaints. It was purely on the procedure, its competency and legality. Why was that rejected, and why did you think it should be rejected?
The view that we took was that it wasn't possible to completely separate out the substance of the complaints from the arguments about procedural regularity or irregularity, because the circumstances and the nature of the complaints themselves and the fairness of that procedure.
But it wasn't about the complaints, it was about the procedure. Didn't need to go into the complaints at all. Arbitration doesn't. It was quite clear, and Mr Salmond made it quite clear in his views, both in emails to the First Minister and in his letters to his solicitors, that this was on the legal basis, competency and legality of the procedure.
And we took the view that it wasn't possible ultimately to separate these things out, or if it had been, then the issue about the substance of the complaints would not have been resolved through that arbitration process, and then the suggestion that would have in some ways avoided a later challenge in judicial review, it didn't seem to be us to be correct.
Perhaps we can make more progress, Convener, if I ask you, Mr Cackette, about the expenses which were paid on an agent and client basis. A scale the court has discretion to apply where one of the parties has conducted litigation incompetently or unreasonably. Yeah. And I have to say, from your last answer, that perhaps is not unsurprising. Can you outline the heads, as mentioned by the Lord Advocate, that justified this highest of all legal scales?
Yeah, I mean, it certainly seemed to us that the nature of the way in which the litigation had been required to be resolved, and that was because of the way in which the interactions that the investigating officer had with the complainers, and the timings of how that had arisen, and the way in which it took through the specification of documents, and then on to the stages where a commission in diligence was required, was something that I think would made it quite difficult to say that this in that respect was kind of, like, normal litigation. In my experience, the commission and diligence specifications of documents are relatively common. Commissions and diligence I've never come across before. So I've never come across a situation where a petitioner, in effect, was forced to go into that situation where they not only served the commission and diligence, but that it proceeded in the way that it did. And so it certainly seemed to me, whatever adjective you choose to describe it, it certainly seemed to me to be very difficult to say, given the way events had panned out, that it would be wrong to have allowed the higher level expenditure on behalf of the petitioners.
That sounded a bit complicated. Perhaps
okay.
You can write to the committee
well,
once you've had a chance
yeah.
to think about this and explain precisely the heads that justified the expenses being paid on that basis. Finally, Convener, I wonder if the total cost associated with the judicial review was £630,000 of taxpayers' money, and that included the net cost of external legal fees incurred by the Scottish Government in defending the judicial review. That came to £118,523. Can you break down how this sum was arrived at?
Oh, so I'm sorry. I don't have. Again, I can write with the detail of that insofar as I can. I don't know the precise details of how it had broken down in terms of council's cost. I'm guessing you're referencing.
Well, I wonder if you could confirm. Obviously, it included the cost of senior and junior counsel.
Yes, indeed.
Are you aware of any other costs incurred by legal services that was part of that £118,523?
There were other legal costs involved through other agents that had been involved, other legal agents that were involved. From the Scottish Government perspective of the cost that we incurred. I don't know if it's counted in 100,000, but obviously there was costs a little bit harder to calculate what they are in kind of time sense of the legal time that was incurred by members of my directorate. I mean, I guess you could make an estimate of that, and we could sit down and work out how many hours individual lawyers spent doing things and tot that up to get an overall global cost. But that isn't normally collated as we go. We don't time record in that sense, if that's what your question is.
But you can write back to the committee on how the 118...
Yes, I'm sure we can do that, yes.
That would be very much appreciated. Thank you.
Of course.
Thank you, Mr Cackette. Alistair Allen has indicated he's a supplementary question before I move on. Alistair Allen.
Thank you very much, Convener. The Deputy Convener asked there about some of the reasons for declining the offer of arbitration. In a letter which I think the committee has just released on the 9th of July 2018 from the former First Minister's legal team to the Permanent Secretary, that letter indicates that one of the arguments on offer was that arbitration would avoid, quote, propelling the matter into the public domain. Can I ask, would would it be normal to take a request based on an argument of that kind into consideration one way or another in making a decision about whether to accept such an offer?
I mean, it could potentially be a factor in that respect. I mean, that was my understanding of one of the reasons why it was being proposed. And obviously, we knew then what we knew then when those decisions were made. What we subsequently transpired as the course of what became the judicial review then proceeded. Then obviously the case was conceded. We didn't obviously know at the time of that correspondence that it would go to JR and would lose it. But at that time, it was certainly one of the factors. To me, as I was trying to indicate earlier on, the kind of as important a factor as that, although it plays into it, as important a factor as that is the question of how long an arbitration would have taken to have been resolved. And again, going back to the Deputy Convener's questions in that respect, I would have said it probably would have taken quite a long time to have resolved who the arbiter was going to be. And I know we're disagreeing about the remit. I suspect it would have taken a little bit of time to work out what the remit would be in drawing lines to protect the anonymity of the complainers. And that would have been absolutely fine if everyone had an incentive in order to get an earlier resolution of this. But I'm not sure that this is necessarily in the set of circumstances that arbitration is designed for, where both sides want a quick and ready resolution of legal dispute. I don't think we viewed it in that way. And if that had led to the situation, if it had taken quite a long time, and as I say, it could have taken a really quite a long time. If somebody wanted to drag it out, it would take a potentially quite a long time. And that would play into the question about the maintaining confidentiality until the end of it would potentially have led to a situation where the government might have found itself then accused of covering this up if it maintained that confidentiality for a period longer than was reasonable. So there was all sorts of kind of pros and cons and hazards about agreeing to a process that would have kept this out of the public domain, where we weren't sure at that point, and we'll never know how long it would have taken to agree all these things and get the arbiter to make a decision. And as I said earlier also, there would be no guarantee it wouldn't still have ended up in court. Because, as the Deputy Convener says, if we had found a way to exclude the substantive matters and the factual matters, there's every chance that the former First Minister would have still taken us to court on those aspects. So we didn't know that at that time, but I wouldn't have said it was necessarily a quicker way to resolve this, and it would not have been a way that would avoid a court action.
Is that you, Mr.
Thank
Allen?
you.
Yeah.
Thank you. Yeah.
Thank you.
Thank you. Go on now to Alex Cole-Hamilton.
Thank you very much, Convener. Good morning, Mr. Cackette. I'd like to follow up on the arbitration. And in your answer to Alistair Allen just now, you suggested that at the time that arbitration was suggested by the former First Minister, the government was unaware of a potential plan to take this to judicial review, or that you would lose it. Is that...
Well, no, we're unaware that we're going to lose it.
Oh, okay.
I'm only making that point. It was quite clear from the beginning, from what had been said to us from, I think, the earliest correspondence at the start of March, that through Mr. Salmon's lawyers, they were indicating they had a series of concerns about procedural irregularity, and were indicating that, that they were very much minded, if it hadn't been resolved, to take this to court.
So there's a WhatsApp exchange between Alex Salmond and Nicola Sturgeon on the 7th of June, where in an extensive message, this is supplied in the First Minister's evidence, in an extensive message, the former First Minister refers to multiple offers of arbitration. Yeah. He also refers to his own senior counsel's advice that were he to take it to judicial review, this would be a slam dunk for the former First Minister. Yeah. So all of this is flying around and would have been a factor. Can I ask, At that time, when the offer of arbitration was on the table, at any point to your knowledge, were the complainers made aware of this? Considering, were they made aware first and foremost that there was a question around the legal competence of the investigation, and that there were these two routes that could be taken to resolve that competence?
I think the complainers knew there was correspondence, or had an issue been raised that was challenging the competence of the procedure. I wasn't directly involved in. There was a kind of narrow line of communication. So but on arbitration, no. My understanding is no, they didn't. They were asked about mediation.
No, I know, but we don't want to confuse those two.
But let's keep them very much separate.
Not.
As I understand, not about arbitration.
So they weren't told about that as an alternative to judicial review.
That's my understanding.
And tell me, had a legally binding arbitration determined, as the judicial review did, that the process was unlawful, could the government have then considered the complaints again? Could they have had a whole do-over with new people, perhaps a revised process? Because it wasn't in the public domain, it seems to me that the government might have been able to undertake those complaints again.
Yes, I think that's right. And indeed now the situation is that the complaints, because this process was ultimately set aside by a court, the complaints, if you like, I wouldn't say only technically because I don't know what could happen. The complaints are not yet addressed.
So that's absolutely accurate. But given the winner-take-all nature of a judicial review and the public media circus around it, it is highly unlikely that because of that, those complaints will ever see the light of day through a government process again.
Well, I can't say that.
It's a rhetorical
that's
question. I'll move on. I'd like to talk about the legal advice. Now,
sure.
we understand, and we've heard at the top of the meeting, that the government is citing legal privilege, but you are allowed to talk about the legal position.
Yes,
legal advice and legal position may be different, and I'd like to ask about that particularly. So not asking what the legal advice contained, but did the government legal position at any point deviate from the legal advice?
So did the government's position?
Yeah. So
deviate from the legal advice?
Legal strategy that the government deployed, did it ever deviate from the legal advice
No.
that it retained? So it was always commensurate with the legal advice.
It was informed by the legal advice, and I'm thinking about whether there was any difference between what the government did and legal advice.
I'll give you a hypothetical.
Yeah.
If the legal advice is don't do it, don't engage in the judicial review, and you engaged in the judicial review, that would be a deviation between the advice and
sure.
procedure, the strategy of government.
I can't think of any examples where that happened.
Okay, that's fine. Can I ask, I mean, there was a lot of pressure at the time. Did everyone sort of receive the legal advice in unison? Did they all agree that that made sense, or was there ever dissent?
From ministers?
From ministers, from the Lord Advocate, from the Permanent Secretary?
Well, I can't answer in relation to the Lord Advocate because that gets too much into the legal advice. No, there was no dissent, and no, not a suggestion of saying, we're not willing to accept this advice or anything of that sort of nature. Nobody, from my perspective at least, nobody said to me, I'm not accepting that advice, or go away and rethink it.
I'm struck by your setting aside the Lord Advocate in that.
No, I don't mean set it aside. I just mean because that comes into the source and content of advice.
And you can't tell us why. Okay. Did the Permanent Secretary and the Lord Advocate always agree on the steps that the government should take in the conduct of this judicial review?
There was no question of any disagreement on the kind of core legal advice. I mean, the core legal advice would be framed in terms of what would get you into illegality. What could you not do? How could at what point would it no longer be appropriate to defend the proceedings? And of course, we got to that stage, and the proceedings were then conceded. The reason I phrase my answer in that sense, in that way, is because the legal advice properly taken, as it was done throughout, informs effectively policy choices. And when there's a range of policy choices that are open to ministers, and there's many legal ways to proceed that are obviously ministerial discretions. The law doesn't determine what ministers do. Ministers have a range of policy options within the range of things which are legal. Now, some of those things involve higher risk than others, so I'm not saying the law is irrelevant in that, but our view would be if there's a range of things you can't do because it's illegal, and in the Parliament terms that might breach of ECHR, for example, if we say, so there's places you can't go. But within the range of where you can go, there's a series of choices, and each involves risk, some of which is legal risk, but some of which might be other sorts of risk.
And as with all policy choices, there are tensions.
Yeah, absolutely.
And with all policy choices that involve risk, there are heightened tensions. Did those tensions ever cause anybody to threaten to resign?
Not that I'm aware of in terms of any kind of ministerial or official basis.
Okay. I've got some more questions, Convener, but I'm quite happy to let others come in first, and I'll come in at the end if that's okay.
Yeah. Murdo Fraser.
Thank you, Convener.
Good morning.
Good morning, Mr Cackette. Just before I go on to my question, can I just follow up Mr Cole-Hamilton's last question?
Yes, Chris, yeah.
You said nobody threatened to resign at the ministerial or official level. Did council threaten to resign?
Communications between us and council and source and content of that, I'm afraid, are within the context of LPP. So I should have made that point clearer to Mr Cole-Hamilton.
Okay, thank you. That's a very interesting answer. Can I pursue issues around the detail and the progress of the judicial review?
Yes, of course.
I mean, just to put this into context, I mean, we know that the Scottish Government chose to defend the judicial review. We know that case was then conceded. We know, and the Deputy Convener has referred to this, that the award of expenses made to Mr Salmon was done at the highest level, and that would normally be done in the case of a defence being either unreasonable or incompetent, which is quite a striking description. So we know it went wrong, and we know that the taxpayer had to pay £500,000 to Mr Salmon. So something went wrong here, and something actually went catastrophically wrong. And I think what we're trying to do as a committee is understand how this came about. Now, we know Mr Salmon had taken Council's opinion on his prospects of success. So can I ask, did the Scottish Government commission Council's opinion?
We'd commissioned Council from the stage when the investigation by the investigating officer was underway. So from then on, we'd instructed Council opinion. When a finding was made, there was a cause for concern. We had Council, senior junior Council from then, and then we had those Council through to the end. And at various points in particular, including in the judicial review, I think as Lord Advocate has indicated, the prospects of success was constantly kept under review, including all the advice from all people involved in all of that.
Okay, thank you. I mean, I'll come on to the detailed timeline.
Yes, of course.
I think that's quite important. But just so I'm clear, when Mr Salmon initially intimated his judicial review claim, was Council's opinion externally taken at that point?
I mean, yes, Council had been involved from before, and Council's views were reflected in the answers that were lodged and in the conduct of the judicial review after that, which is reflected in the open record, which I think is one of the documents the committee has.
Yeah. Okay, thank you. And what assessment did the Scottish Government and its Council make at that point of the prospects of success of the judicial review?
At that stage, the position was that it was proper to defend the proceedings because on the basis of the arguments that were placed that were set out in the petition.
Okay, I'm not.
So the
it was proper to defend. I mean,
we thought, we're in a position where we thought the case was winnable and would have been won. Standing that litigation is always unpredictable. You could never absolutely say for any circumstances but we're in that position where it was...
So there was an arguable case to defend?
Yeah.
Yeah, okay. We now know that there was information that was not available or was not disclosed until later in the process. Sure. Why was that failure? Why was the legal position of the Scottish Government not informed by that information that subsequently came to light in November?
I only became aware of that information in the course of the judicial review proceedings as the information was emerging. And indeed, Council 2 were in that position. And so the procedure, the process and procedure that was being applied and the grounds that were taken by Mr Salmond in the judicial review when initially raised, obviously didn't reference that because it only became clear in the later process through the specification of documents that we'll come to. And it was only through that that the significance of that came into play. And obviously you've seen the initial written statement of Scottish Government that was provided earlier, paragraph 39, that sets out the circumstances of why the case was conceded, and indeed the most recent timeline as well indicates, I think this also reflects what Lord Advocate said in his notice, that the decision to settle reflected a conclusion based on the review of the material which had then become available. And that was the key thing against there, that the judicial review should be conceded for the reasons set out in the Scottish Government response, and that's the paragraph 39 reference.
Okay, thank you for that. But you said to me a moment ago that there had been an assessment made of the prospects of success, that there was an arguable case to defend, but then there was information that was not available at that point that subsequently came to light. But does that not suggest that whoever made that assessment of the defensibility of the case hadn't done their job properly?
You can only make an assessment on the prospects of the case on the information you have.
But that information did exist, it just hadn't been found. So whoever was making the decision to defend the case hadn't sufficiently done their homework.
Well, I certainly weren't aware of that information as emerged in the course of the work around the specification and the Commission diligence.
Okay, let me turn to the actual timeline and process of the judicial review, because there were various adjustments made by the Scottish Government to the open record. Now, there was an adjustment made on the 5th of November 2018, which then provided detailed factual information on the development of the procedure and the contact between the complainants, Ms A and Ms B, and senior employees of the Scottish Government. So was that the point at which the Scottish Government realised that there was crucial evidence that had not been previously available to it that put its legal position in a much weaker situation than it previously had been?
Those adjustments were made in response to adjustments that the petitioner had made slightly earlier than that, in fact, but the timeline. And that had raised a question and a call on Scottish Government. This is in the timeline, and at page 9 of the timeline, it was 23rd of October that the question first arose, where the petitioners were asking that question. And it was in the period then towards the end of October and into the beginning of November. And there was a procedural hearing on the 6th of November. And it was around that that we then started a process, first of all, through the formal legal process of making adjustments to respond to that, to make sure the Scottish position was accurately and correctly narrated to the court. But separately from that, that's when the question started to arise as to try to ascertain what this meant, what had happened and what was going on. And it was really from that process onwards and leading on to the specification, which was around the kind of middle of November, that the questions then were starting to be asked, actually in two respects, one of which is the kind of, what's this issue? And then separately, because there'd been a specification by Leave and McRae it was given in draft on the 2nd of November, and that was later taken forward. That led to a situation where I started to undertake an exercise trying to find the document. So there's two separate things, if you like. There was, what does this mean? And who do we need to ask to find out what this means? And that actually was a relatively small number of people, because this had all been kept, was for understandable reasons kept quite tight. So it wasn't a huge number of people. But what was done at that point was then trying to work out, what's the significance of this? What actually happened? Because people were obviously, those who were involved at the time knew about it, but they were now being asked a year later. So there was a bit of time taken to try to work out what was this about and what's the significance of it. And then separately from that, there was the finding of the documents.
Okay, thank you. And then there was a further adjustment made on the 20th of November 2018, where answer 19 was adjusted by the Scottish Government to state, and I quote, that prior to her appointment as IO investigating officer, Ms McKinnon had involvement and contact with the complainers.
Indeed.
So that, again, that come out of the Commission on Diligence, had it?
That had come out, no, the Commission on Diligence was a little bit later. That had come out from the searches that were then done for documents which were provided to Leaven McRae. I think that's page 13 of the timeline. On page 12 of the timeline, you can see a reference to 3 tranches of documents. This is 16th and 21st November. 3 tranches of documents were sent to Leaven McRae. There was actually once on the 16th of November, a further bunch on the 19th of November. Then actually they were all collated into a third inventory of productions, and they were sent in response to Leaven McRae's call of the 12th of November. So it was the documents that were emerging from that point that would gather together, and as the timeline recognised, there was 110 documents. And so it was the collation of that information, as we had it then, plus the process of examining what all of this meant and what was an understanding of what had happened before, that led then to those further adjustments.
Thank you. At what point between the 5th and the 20th of November did it become clear to you that this was a fundamental change in the Scottish Government's case?
I mean, it was clear from my first becoming aware of it that this was potentially a significant problem.
And when did you first become aware of it?
I first became aware of that towards the end of October 2018.
Right.
I'd first seen something in writing, I think the 31st of October, but that wasn't the first I knew of it. I knew a few days prior to that. It's the last few days in October.
And when you became aware of that, and presumably at that point, you must have realised this was very damaging to the government's case.
I realised that if the circumstances were as they were set out by the petitioner, then that was a potentially serious issue, right, and had to be really looked at. We had to find out and properly ascertain what the factual circumstances were. And then we'd take a view, obviously, once we'd done that, as to what that meant for our ability to defend, etc.
Were your concerns at that point shared with the Permanent Secretary?
I'm pretty certain they were. I can't precisely say, but they certainly were. They were very much shared with effectively, we had a coordinating team who were taking responsibility, if you like, for the policy instruction, and that was within the Permanent Secretary's office, because it was her procedure. The officials who were our first report for call were in the Perm Sec's office. I mean, I would presume the Perm Sec would know, but I can't say for certain. But it certainly was through her office.
Right. Okay. And the Lord Advocate, he would have been.
Yes.
He would have been aware of this.
Yeah.
Right. Okay. Okay. So we came to a point, end of October. It became clear that there was a significant flaw in the Scottish Government position, of which you had not previously been aware. I suppose my question is, why did it take until January before the Scottish Government made a decision to concede the case? Why did it take more than 2 months?
That led into the process of identifying the documents and trying to establish what the factual circumstances actually fully were. and the development of that through, as you can see from the timeline as it develops, it involved a number of stages in all of that. And actually, it's quite telling in some ways that the initial indication from Leaving McRae towards the end of October, there was a specification, then a further call on the 12th of November, they intimated a further request, then a subsequent specification, is that it took time to work out what this actually really meant. It wasn't really a kind of, in that sense, a slam dunk moment. There was work that required to be done, and we required to try to establish what the full factual circumstances were, and then work out whether, as indeed is set out in the grounds for the ultimate concession, whether the combination of the wording of paragraph 10 of the procedure, along with the facts as they were emerging and continued to emerge as we found out more and more, actually had that effect.
Okay, and one more question, Convener, if I may. We've already talked about the award of expenses at the highest level. Was the award of expenses, which I believe was agreed by the Scottish Government, did that reflect the fact that it had taken some time for the Scottish Government to reach the point of conceding the case?
Yeah. In a sense, yes, because having taken so long to have got that stage, the commission diligence became essential. Yeah. And so they're all linked in. I mean, I think the fact that, as I said in the response to the question earlier, a commission diligence is a pretty rare beast.
And expensive.
And indeed expensive. It was set down with a senior advocate, initially for 3 days, only actually ran for 2, as it turns out, because of the circumstances. But yes, the need to go to that, certainly that in itself added to the expense.
Okay, thank you very much.
Jackie Bailey.
Thank you, Convener, and welcome, Mr. Cackette.
Yes, good morning.
In response to Margaret Mitchell, you indicated you would give us a breakdown of the 118,000 that was spent on external counsel, but you also very helpfully indicated that you could probably provide an estimate of the amount of money spent internally by the Scottish Government. And I would be very grateful if you would send that to the committee, because clearly this has involved a significant amount of time and effort within the government, and just having an appreciation of that would be very helpful. So can I take you up on that offer? Thank you. Can I just take you way back, just so that I'm clear about timelines? Were you responsible for any of the legal advice when the policy was devised in November 2017, December 2017?
No, I wasn't the legal director at that stage.
So who was responsible? I mean, I don't need a name. A title would do fine for actually providing the legal advice for the development of the policy.
Well, it would have been provided by my predecessor, effectively, or if you like, in the name of my predecessor, who would have done, as I've sought to explain my role, is not maybe dealt with the kind of individual minutiae of every particular individual aspects, but would have assigned the role to an appropriate official or group of officials within a division there.
Okay. Well, Judith McKinnon, in evidence to us last week, said she got advice throughout the process from an employment lawyer. I'm assuming that's somebody within the civil service. Is it appropriate for us to know who that person is?
I'm afraid I would say no, because that would indicate source and content, but it was an employee of the Scottish Government.
Okay, well, let me ask you, were you aware subsequently of those discussions, the advice given at that stage? Because obviously you have a coordinating role.
Yeah.
I'm assuming that lawyer still worked for the Scottish Government and therefore would have information to provide.
I wasn't aware to the kind of minutiae level of every single bit of communication, but yes, I was aware that the advice had been given and who had given it, and the generality of what had been given. Okay. You know, looking backwards.
Did that cover the involvement of Judith McKinnon as the independent officer, or the investigating officer?
Yeah. It involved all aspects of the advice, both in relation to the development of the policy and questions based on the information available to the lawyer concerned on the question of appointment.
So when did you have that discussion? Given that you were, newly into the role of coordinator, was that early on in the process, just to try and find out, by way of background, what had happened?
Not that discussion in that respect. I mean, as I say, I found it a little bit later on. I mean, obviously, I did have a bit of a discussion. I found out that the complaint had been made and was being investigated as a cause for concern. I think it had been held as a cause for concern by that stage on my third day in post. So for the first I knew about, I know.
Lucky white heather.
the first I knew was then, and in discussions on that day, it was explained to me what the general background and what the context of what this was. Obviously not in kind of that level of minutiae of detail, but yeah, I mean, I knew enough at that point to know that there had been the procedure and that who'd been appointed and the like to help inform my understanding of going forward. What I should say, of course, is feeling like an 800-metre runner. Starting halfway through when everyone else is sprinting and you're going for a standing start. There was quite a lot that was ongoing at that point, particularly as when I started, we were in the middle of correspondence with Leith and Becrae about the procedural concerns about the then ongoing investigation with the IO. So there's quite a lot going on. I
appreciate your difficulty. What I'm trying to establish was, at any stage, did anybody tell you, as you were coming up to speed with this, that actually Judith McKinnon had prior involvement with any of the complainants?
No, I wasn't.
You didn't know that? Okay. Again, last week, Judith McKinnon suggested that the final version of the policy was somehow different to earlier iterations, specifically in relation to paragraph 10. I wonder whether I could read to you the very first draft of the policy, where it talked about, and I quote, nominate a member of the SCS who had no prior involvement in any aspect of the complaint. So would you agree that the point was actually clear from the start?
From the initial version?
Yes.
Was
I've just quoted to you the words in the very first version of the policy.
And so you read it again, please? Yeah.
Okay. This is the first draft of the policy, and it said, nominate a member of the SCS who had no prior involvement in any aspect of the complaint. So my question is, would you agree that that point was actually very clear from the start?
Well,
I mean, there's no way of misinterpreting this.
No.
Surely.
Again, I mean, you've heard evidence from James Hind, and indeed attached to the timeline that's his indication of what that meant.
But I'm asking you, as the person who was coordinating the government's response to the judicial review, somebody who obviously thinks carefully about his words as a lawyer, that there was no difference between the first draft of the policy and the final one in terms of what the intent was. Surely we can agree.
I'm certainly struggling to see a difference. Yeah.
Okay. Yeah. Thank you. That's all I'm trying to establish. So let me come back to when did you know that Miss McKinnon had extensive prior involvement with complainants before she was appointed as the investigating officer?
That was again at the end of October 2018.
End of October. Okay. You'll forgive me if I go over some of the ground that my colleague went over. I just want to fix this in my mind. At the end of October, did you warn colleagues of the implications of this? What action did you take?
As I say, we had to investigate the context of what this meant. I think everybody who was involved realised that this was a potentially significant issue. I don't think no one needed to be told.
So what action did you take? Was there a discussion with council? Was there a discussion with Judith McKinnon? I'm kind of interested to unpick that.
At that stage, I didn't have direct discussion with Judith McKinnon, but what we did was, as I said in answering to Mr Fraser's question, I think it was Mr Fraser's question, about how we coordinated the work through the Permanent Sex Office. Then, at that stage, that office then started a process of trying to work out what the correct factual narrative and circumstances were, who spoke to you and whatever, and then trying to work out what it all meant. So,
but as you said earlier, and I'm quoting you correctly, this was the perm sex procedure.
Oh, indeed so.
So she would have conceivably known. She was party to some of the email traffic.
I mean, yes, it was certainly her procedure. It certainly was adopted under her auspices initially, yes.
Okay. Can I take you back to some of the meetings? Because there's a very interesting Freedom of Information request that was published on the 13th of September 2019. It lists 17 meetings with Council. Okay. Can I just pinpoint, when was Council first involved? Was that at the 23rd of August? That's the first meeting listed?
No, Council was involved from around the time I was appointed. A junior was involved, I think, before, and I was involved in commissioning senior counsel to be involved now. That first meeting would have been a meeting specifically in relation to the judicial review, which only it effectively occurred on the 23rd of August, because that was the date in which we were given intimation of a draft petition that was serving us the next week.
So Council were involved before that, but this only on the 23rd of August in relation to the judicial review.
Exactly so.
Okay. They went on to be involved to the 7th of January, and let me ask you this. It was the same Council throughout?
Yes.
Okay, that's very helpful to know. Would it be fair to say, and I'm not asking about the advice, I'm asking about the position on prospects of success. Did that change?
Well, yes, but it did ultimately change, yes.
Okay, but let me come back to something you said to Murdo Fraser, because your response to Murdo Fraser was it was proper to defend. And you picked your words very carefully. What I'm asking you is, at that initial stage, what were the prospects for success? And I'm not asking for the content of the legal advice, because the question posed is different to your response.
Sure.
You're answering a different question, with all due respect.
I mean, the prospects, as we kept content under our reviews as they went, it was only at that stage, at the end, leading up to the concession on the 2nd of January, that it become clear that it would be improper to defend. If I could put it like that.
So
you get different views as you go. Any litigation goes up and down a little bit, but and as information arises and as you develop your potential answers. But at the point of the concession, that was the point at which it would have been improper.
But you could have a position. Forgive me, I'm not a lawyer, so I'm just exploring this with you. You could have a position where you would consider it proper to defend, even though the prospects of success weren't good.
Yes, that can always happen.
Okay.
And there can be circumstances in which you get different sources of advice from different people. Council's advice is not the Scottish Government's position that informs the Scottish Government's position, etc.
So Council could have said to you, your prospects of success aren't really good here, and the Scottish Government could decide itself, well, we're going ahead nevertheless, it is proper to defend.
It could
that
do
would
that.
be consistent with what you've told
us.
Yes,
and that's right. If Council had said it's improper to defend, then that's very different. And we did not defend beyond the stage in which it was suggested to be improper.
You got to a point where the game was up. I think would be the description. Okay, can I just ask you again to aid my understanding? Lots of people are listed as exempt in this FOI from being named as being at the meeting. Would that typically include the lawyers for the Scottish Government, the Lord Advocate, Senior Counsel, Junior Counsel? Is that a fair interpretation of the people that are likely to have been there?
There's two sets of people who are noted as exempt, one of which is the lawyers involved, and the other are non-senior civil servants.
Okay, good. Okay. Can I take you to the meeting on the 19th of October then? That was the one attended by Judith McKinnon, Dr Nicola Richards, James Hind. In evidence last week, Judith McKinnon said she spoke to external counsel. Was that at that meeting?
That was one meeting I wasn't at. I'm sorry, I was on leave that week.
Okay, lucky you. But I'm sure as the coordinator you would know all about it. That's
in reference to one of my answers afterwards, it was in the period after I returned from leave, was the point at which I was told.
You became aware?
I became aware.
But was it the case that at the meeting on the 19th of October, Council became aware of Judith McKinnon's involvement?
I don't know if I could factually answer that question. I mean, I suspect that Council would have known that Judith McKinnon was the investigating officer.
Yeah.
But I'm not sure I can say more about that at a meeting.
Could you find out? I mean, if it's you know,
I can.
I'm wondering. So, for example, from that meeting, did somebody prepare a report for council on the extent of the involvement? Was that when the red flag went up?
Yeah. I can certainly ask for to see if we can provide a fuller answer to that, subject to any LPP issues around that.
Okay. Because I'm just conscious that we have a meeting with Judith McKinnon and external counsel on the 19th of October, and then a meeting with a cast of thousands that can't be named on the 23rd of October, and Judith McKinnon wasn't there, nor was she there at any of the other meetings thereafter. So it seems to have been established on the 19th of October there was a problem.
Well, certainly, well, as I can't see what happened on the 19th of October, but certainly it was in the period after that that there clearly became an issue arising.
Okay. So it would be safe for me to infer, given that you weren't there, you were on holiday, that actually on the 19th of October is when the government became aware. A report may or may not have been made to council, and on the 23rd of October a cast of thousands meets because something I'm inferring from this seems to be wrong. Yeah. Would that be fair?
I think you can draw your own inference, but I don't think I can comment more than that.
Okay, well, if you can provide any further light on this, I'm sure the committee would be most grateful. So at what point did external counsel say to you there's a difficulty here?
That, again, I can't answer that. That involves source and content of advice.
Oh, okay, sorry. I just thought because it was a process issue, I would be able to ask that question.
I don't think so. But again, I can take...
Well, you're the lawyer here, I'm not. I'm just curious...
I'm also a witness to this. I'm not the current Director of Legal Services.
Okay.
But
you never leave it behind.
No, you never can.
Let me just ask you. You came back from holiday. You were aware at the end of October, but Council could have been saying, between the 19th of October and the end of October, we have a problem. They could have been.
It could have been, yeah.
They could have been. Thank you. That helps my understanding. Can I ask that there's a meeting listed here, 13th of November. It lists the First Minister, Elizabeth Lloyd, the Permanent Secretary, and Council, one would assume. Maybe. Why was there no SGLD official there? Do you know?
No, I don't know.
Okay, you don't know what the meeting was about? Even though you're responsible for coordinating everything? Yeah. Okay, fine. In addition to the 17 meetings with Council, okay, we heard that there were catch-up meetings 3 times a week. Were your staff involved in that?
There were a series of meetings. I think the reference to 3 times a week, I think, was from last week's evidence with Barbara Allison.
That was the first we heard about it.
Yep. Absolutely. I was involved in daily meetings with the Perm Sex coordinating team, which may or may not have been the same set of 3 times a week meetings, but the meetings I was involved with were meetings with a sort of regular catch-up on the kind of handling of where we were and planning the kind of next steps, and that involved the officers from the Perm Sex department and almost invariably COBS people involved in that as well. Okay. Although I don't think I would say that people like special advisors were involved in all of these meetings or even to the frequency of 3 times a week, it was certainly there were occasions when SPADs would have been at these meetings, especially at points when there was a kind of an external statement of the Scottish Government position, a procedural hearing, for example, and so the comms handling of that was something that special advisors would have a close and legitimate interest in. So there were meetings that took place on a regular basis, which I would usually attend with members of my staff.
So let me just be clear about this. You talked about daily meetings. When did they start? When did they end?
The daily meetings were more or less all of the time. From when I took up post, and I think probably through to the end of the JR, actually.
So sometimes the Perm Sec would be there, but it would certainly be all her staff.
No, her staff.
Her staff. Okay,
I don't think she was ever at any of them. It was her.
Okay. But she would be aware of what's going on, because if her private secretary is there, you know, she would definitely. Yeah. Okay, that's fine. That's fine. Can I therefore ask, at these daily meetings, did you discuss with them specifically the problem that you were alerted to at the end of October with Judith McKinnon?
The detail I can't talk about, but yes, we knew that there was things that had to be looked at. Yep. And that involved, in particular, issues that were obviously unfamiliar to lay people around what specification of documents is and what commission diligence is.
Sure, but you were aware, the end of October, that there was a problem here. Okay.
There was an issue to be addressed. Yes, absolutely.
And in that respect, did you provide advice to the Permanent Secretary, given that it was your role to do so?
I provided advice to the team I was working with on that. There was ongoing advice regularly given in that period.
And at that stage, did your advice touch on the prospects of continued success of the case?
The advice at that stage would have been informed by such factors if we were reaching the stage that the prospects were now moving to a position where it was becoming an unstateable case. So
sorry, I'm a very simple soul. Does that mean you thought you were on a hiding to nothing and you told the Perm Sec that in fancier language?
It's the other way around.
It's the other way round?
It's the other way round.
Do explain.
Is that unless and until we got to that stage where we felt that the case was unsustainable, that there was no reason every day to say, by the way, the case is still okay, the case is still okay, if you see what I mean.
I don't really.
No. So I didn't go home every night thinking, is the case still okay? Yes, it is, I'm fine, or give advice to that effect. That's not how advice works, if you see what I mean.
So I'm curious then, if you think that there was a fatal moment, as we would see it, where the role of the investigating officer clearly was tainted by bias, I think is the language that was used, because she had a substantive role in advance of appointment, recognising that was a real problem, you didn't advise the Permanent Secretary that actually we are in some difficulty? I'm curious to know why the Scottish Government chose to keep going for another 2 months, at cost to the taxpayer, and not concede the case when you as a lawyer would have known that the game was up. Well, you're a good lawyer.
Yeah, I don't know if it is right to say that I would have known at that point, because we still had to ascertain what the facts were.
Okay. How long did it take you to ascertain what the facts were?
Well, the work then proceeded in relation to the specification of documents, and more documents emerged in the course of the specification, and then ultimately in the course of the commission and diligence.
Did you go back to the lawyer that advised Judith McKinnon along the way and ask for more information?
The lawyers, including those who were involved at the time, continue to be involved at all stages in that.
So this individual was still involved in the judicial review process and didn't kind of alert you to this information, didn't provide the clarification required, nothing, silence.
He alerted me to the information that he was aware of.
He wasn't aware of this?
Well, no, I'm not saying he wasn't aware of the generality of this. What I'm saying is the detail of what emerged only became really clear as we moved into the commission diligence.
Okay. Can I ask you, did you at any time tell anybody, Judith McKinnon, anybody else, that it would be possible to assist the judicial review if the police investigation could be moved forward?
Put in that sense, no.
But in any sense, you choose to
any sense, no. We could think of assisting cases, but
that never that was never suggested.
I'm just trying to understand that the question infers that if we could somehow persuade the police to do that, could we assist? And that's what I take issue with. There was no suggestion on my part that we tried to influence the process. If, on the other hand, it had been the case that a police investigation were initiated, I think I would have been firmly of the view that it ought to be insisted in order to let the criminal process due process. And a criminal, in that sense, is more important than civil for various reasons that are fairly obvious.
Sure.
So
did you ever discuss sisting the case?
Sisting would always be an option in relation to these cases.
I'm just asking, did you discuss it?
Well, again, I need to be careful about the kind of the content of this, but I wouldn't dispute the fact that the idea of sisting would have been a perfectly appropriate thing to have done if the circumstances had required it. And the most obvious one would have been, looking back, had the charges been preferred, say, in the autumn, when we were still working through the case. If I could answer this in the abstract, to avoid me getting into specific legal advice, I think then I'd have said definitely. I suggested it from our perspective. I would have said that would be something you would want to do.
Can I just push you on one final question, because I don't want to, take the convener's patience in vain. So I'm still not clear why it took you, not you personally, the Scottish Government, till January to concede the case. Why did it take so long, knowing what you knew?
Well, what we knew emerged and developed, and our assessment, of the circumstances emerged as we go. Obviously, this case, as much as any, was obviously extremely important, extremely high profile. But all cases, all litigation, in my experience, is something of a roller coaster where your prospects go up and down. And this, I don't dispute this was significant. I'm not trying to diminish that aspect for a moment. But we were due to be going into a 4-day judicial review on the 15th of January. We went through a process, again, perhaps reference the timeline is maybe relevant here, in looking at the ways in which we were considering our responses and how our adjustments to our position could put in a fair position before the court what our views were. And it was in the kind of only in the development of that and the thinking of what our response would be that we reached a view. Because a number of things come into play, one of which is the factual circumstances. The other is the analysis of the documents that were emerged, and the third is the question of the legal prospects as you go. And one of the things you would think about, again, trying to put this on an abstract level, is even standing this difficulty that clearly had become to our attention. Did it follow that meant the case absolutely had to be conceded, or were there things that we could say, if you see what I mean? So the time was taken, and time would be taken then to analyse any legal precedents, and what procedural fairness means, what apparent bias means, and how that takes time to work through.
Okay, thank you, convener.
Thank you. Mr Cackette, thank you very much for giving us so much time, and I hope you'll bear with me a little bit longer. We've had a lot of information from you, and thank you for that. And there's a couple of things I would just like to clarify in my own mind. Please excuse me if you've gone over it already. There's been a lot to take in. The first thing, just to get clear with me, is you reported to the Director General for Constitutional Affairs.
Yes.
Just refresh my memory. Who was that?
It was Ken Thompson.
Ken Thompson. Yeah. Thank you very much. And did you deal a lot with Ken Thompson at the time over this particular issue? Or was it, as you said earlier, very much the Permanent Secretary's procedure?
It was very much the Permanent Secretary's procedure. I didn't deal in any way with Ken Thompson up until the point at which the JR started, because of the way we were structuring things to keep the confidentiality of this as narrow as it could. And so my dealings were effectively through the Perm Sex office at that point. Once the JR started, I said a bit more to him, because I was more at liberty to do so. But to all intents and purposes, it was proceeded through the Perm Sex office rather than my own Director General.
Yes, so you worked. I think, Alison, do you have a supplementary to that?
Particular point. But
All right, yes, we'll try Mr Cackette's patience for even longer then. Thank you. Can I also ask, you talked about the missing information.
Yeah.
I mean, there's been quite a lot of discussion about that and when it came to light. Which department was actually tasked with supplying that information for the judicial review?
So is that in relation to the emerging difficulty?
Everything. You know,
right.
you've got a judicial review.
Yeah.
Information is obviously required. So
Yeah.
who was responsible for that?
In that sense, again, the coordination was through the PermSec's office. Because of the high-profile nature of this and the sensitivity of the information, the number of holders of documents and people who were looking for information on that was actually relatively small. In other circumstances, and perhaps more typical litigation, there might be a much broader involvement of people, but actually it was very much that kind of narrow group through the PermSec's office, through the likes of James Hyde, who you've had evidence from, and from people who we thought were involved in the development of the policy and its application, such as Judith McKinnon and Nicky Richards, who you've taken evidence from. So it was a pretty small, compact group of people.
Mm-hmm. Was it the same group of people who were tasked with going back to see if they'd missed anything?
Yeah, but in effect, I mean, that was a number of things were happening in tandem with each other, and it was the same group who had the knowledge and understanding of what happened at the time to try to make sense of it, were also the same people who, in that very tight group, were the holders of the documents concerned. And one of the difficulties arose in trying to identify the documents, although this was kind of later in the process, by the time we were heading towards the Commission diligence, was that some of those officials were then had gone off on a lengthy Christmas leave. One of them particularly had left on the 14th of December. I remember the days when you used to be able to go to the Far East for your holidays, for long holidays over Christmas, and that actually did give rise. That did give rise to actually some practical issues, especially at that point in searching for documents, because they were in people's email accounts and H drives that they had access to and they knew the passwords to, and it was quite difficult at that stage. I'm not saying earlier in the sort of November period, but at that stage, as we moved towards the Commission and diligence, actually there was a real practical issue that arose of actually getting hold of documents. And so, for example, although we ultimately required to find a way around this, it wasn't really possible to ask other people to search their inboxes, like IT people, just because of the sensitivity of the information you're looking for. So actually, there were a number of practical problems. I think if I had more time, I could maybe try to...
You can have as much time as you like.
Well, I'd be delighted to give more... I'd be very happy to give more colour to the challenges that were faced in dealing with the specification right from the beginning and throughout. One of them was an issue about people who weren't there. Others were issues about the extent to which we were able and had properly identified things like search criteria as to what to look for, and people were it was a relatively small number of people, and that was an advantage and a disadvantage. The advantage of it was being a small number of people, therefore we were able to ask for that information without asking the entire government to be searching, because that would be completely inappropriate to do. So we couldn't treat it like an FOI request, which actually the Commission in some ways, a specification of document of the Commission in some ways is quite similar to an FOI request, except that you don't apply exemptions effectively, rather the Commissioner applies exemptions. So it was a smaller number of people who were asked to do these things, but at the same time they were also, by virtue of being that small number of people, they had a task that was enormous to do, as it transpired, looking at the amount of information that was there. And again, the question is of how we were able to access and check email accounts and no doubt password protected H drive documents and various things, and people were out the country.
I'm glad you're happy to be generous with your time, because I'm having all these other requests coming in. If I could ask members to be fairly brief with their questions. Alison Johnson, then Angela Constance.
Thank you, Convener. Is it your view that the Scottish Government considered that it had a robust procedure in place for dealing with the harassment complaints?
Yes, I mean, the legal view, the collective legal view was yes.
And would you agree then that to be considered robust, a procedure would actually have to be very carefully adhered to?
Well, yes.
Yes. So obviously, the much quoted paragraph 10, which says that the investigating officer will have had no prior involvement with any aspect of the matter being raised.
Yeah.
It just seems to me that that paragraph was always sitting there. You know, so is it your view that the government's case was ever okay then? That it was ever strong, given that paragraph in the procedure is sitting there and it hadn't been adhered to? Yeah.
I mean, I'd refer generally, as I say, to paragraph 39 of the government's statement produced in September. And the reason I reference that is because the legal position is assessed in the context of the reading of that paragraph with the facts and the circumstances applied, and that's where the concern arose that was the ground of concession eventually. Paragraph 10 in itself, looked at in isolation, there's in a sense nothing wrong with that. It's as you'd be saying, it's how it's applied in the circumstance. Now, James Hind has given evidence before, and he's produced a document that explains what it was endeavouring to cover. But if you look at it even now in its terms, I don't think there's anything wrong with that, as long as the facts, as applied to the right facts. So if a different investigating officer had been appointed, for example.
No, absolutely. If an investigating officer had been appointed who had absolutely no prior involvement with any aspect of this case, then I'm sure the outcome...
been very different. So it's the combination, all my point is the combination, I think, is the point I'd make.
Yeah, absolutely. So, you know, just for clarity, you've suggested earlier that the government's position didn't deviate from the legal advice, or didn't deviate substantially from the legal advice. So the legal advice wasn't fully informed.
It was in the development of the policy. It was fully informed at the time that the facts as emerged towards the end of 2018, as read with the policy, led us to that conclusion that it was the risk of an appearance of bias occurred.
Okay. So, in your view, was it legal advice given on the basis of insufficient information, or only part of the information that was required to fully formulate a proper view? Yeah.
I mean, the final view was reached on the basis of the information we then had, as has been said in the statement before. It was based on the view of the information which had by then become available. I can only refer to the timeline from last week. So it is the information that had by then become available.
So is it your view that very pertinent and relevant documents simply were not made available at the time they should have been?
Again, no. My view is consistent with what's said in the statement there.
Okay. No further questions, Convener.
Thank you.
Angela Constance and then Maureen Watt.
Thank you very much, Convener. Sorry to prolong the carry-on lawyers routine, but could I ask, can you tell us, Mr Cackette, how many lawyers have been involved in this saga, both internally and in terms of junior and senior counsel?
There's a question. How many in total?
More than 10? Less than 10?
Probably around.
Pick a number.
I'm probably around it. I'd like to think about the precise number at various points. It's probably at various the whole process is probably the different aspects of things, probably around 10 or 12, I'd have thought, from the legal directorate, looking at different aspects of things.
Okay, so that's That's a fair number of folk from the learned profession. Did anybody ask or even think about asking Miss McKinnon if she had any prior involvement with the complainants before taking on the investigating officer's role?
I don't know what was asked around the time that she was involved in the taking on of that role. From my perspective, I didn't ask that question from when I came into post, because I didn't know of that issue, and I didn't really have any reason to ask for that. I think that's probably true for a number of people.
So none of the lawyers involved in this situation thought it was something that should have been asked of Miss McKinnon in terms of her history with the complainants. Nobody thought about asking that, and I'm struggling to understand why you, as the head lawyer, if you like, weren't aware or appraised of, what the entire legal team were asking, thinking, past and present. I appreciate you were, landed with this position, but
I'm not sure what the question is. Sorry. So why wasn't I?
Well, why were you not aware of what your colleagues were pursuing or asking? I mean, presumably, I'm not a lawyer, but it would seem like a basic need for all the information to be on the table for all the lawyers. Sure. And yet you can't tell me whether any lawyer thought it was, whether indeed they asked Miss McKinnon about her prior involvement. Yeah.
It clearly was the case that the absolute significance of this only emerged in the course of the judicial review. So it may well be that's why it wasn't thought to be something that would have been explored and investigated at that time. I mean, it's something that had the kind of it was if you like at the kind of roots of the start of the process.
Yeah, I'm just curious as to why no lawyer thought it prudent to ask some in-depth questions to the investigating officer about process that included prior involvement. But it's all going to remain a bit of a mystery, apparently, Convener. Can I just finally ask if Mr Cackette could just summarise in plain English why the government decided to concede the case?
Sorry, I missed the very last. I got to the plain English point, didn't hear the last bit.
Can you concede? Sorry, can you explain in plain English why the government decided to concede the case?
I think that the most I can do is repeat. I can read it out again, but reference to paragraph 39 of the statement. That it was a review of the case informed by legal advice. The combination of those two factors, as I said to Alison Johnson, impacted on the case. That is the meaning of paragraph 10. Although it was clear to those involved in the development of this operation, it was obviously open to a different interpretation and to what prior contact meant. And then, having regard to the totality of the investigating officer's dealings with the complainants before her appointment, the reasonable observer could conclude there was a real possibility she could not act impartially, as she was required to do by the procedure.
Was that plain enough English for you, Ms Constance?
I still don't know why nobody asked Miss McKinnon the obvious question, but we'll leave it at that.
Okay. Maureen Watt, then Alex Cole-Hamilton, quickly, and then we'll wind up.
Thank you, Convener. Good morning, Mr Cackette. Clearly, all this work was going on in the Scottish Government Legal Department with advice coming from council and all that kind of stuff. How often were briefing papers on this sent to ministers, and which ministers? And were you involved in writing any of them?
Yeah. I mean, briefing papers, anything that would be given by way of briefing to ministers, because of the nature of this case, would have had legal content and legal involvement in it. I'm trying to think of the frequency of this. I know that there was a paper which I think Aisha Sarah Davidson, who's due to come on after me, was principal drafter of at the end process when we gave advice in a collective way in relation to the conceding of the case. The speed of which matters progressed was such that we didn't give kind of regular updates in that sense. I mean, I'm not saying ministers didn't know. There was regular discussions and regular information given to them. But it wasn't done in a kind of like a weekly briefing or this is what's happened here or whatever. If there were significant changes of circumstances, then advice would have been given. As I say, the crucial and important one to that was the report that's prepared to the end. But ministers were involved and informed at all stages. But the speed at which matters went is it wasn't really set out in the sense of kind of significant briefing or in that sort of or kind of methodical briefing, if you like, in that kind of way.
But excuse me, but ministers are normally informed by written briefings.
Oh yes, yeah.
So you're saying that ministers were not given a formal briefing on this till the end of the process? A formal written briefing on this till the end of the process?
No, they got written briefing. What I'm saying is they weren't given sort of a kind of a commentary as we went as to what the prospects are as of now. And the current situation. They were given briefings, and that included written briefings, of the development of the case. And as matters emerged, they were fully informed.
But not written, regular
well,
written
not written in the sense
not
of...
Not something that they could give feedback on?
That I could give feedback, or the minister could give feedback on.
Ministers could give feedback on.
Well, I suspect they could give feedback on it, but not the briefings weren't really prepared in the sense that those around the room who've been ministers will expect the normal briefing to have been given. But it's not to say they weren't told about significant issues as they arose.
So are you saying that it was just in kind of informal chat?
No. What I'm saying is that there were discussions, but there was also written advice given, but not in the kind of ministerial submission sense of the word, to any great extent.
So there were no regular ministerial submissions until the very end of the process.
Yeah. It was such a fast-moving set of circumstances that there didn't really need to be in that sense.
Okay, so the recommendation or the decision to reject arbitration, was that written or was that just a kind of informal chat? Or?
Well, no, that was written, but that was in July. And so at that point, whatever the WhatsApps might have been separately, the procedure was such that the First Minister and other ministers were not aware through the procedure. However, it might be suggested they were otherwise aware. There was no advice given to ministers in relation to those aspects of the conduct of the procedure because it was the perm sex procedure.
Okay, I think we've heard that before. Thank you.
Okay, you'll be pleased to know, Mr Cackette, that I'm putting my foot down. So it's a very quick question from Mr Cole-Hamilton, followed by an extremely quick question from Miss Bailey.
They will be quick.
Cole-Hamilton.
Thank you, convener, and thank you for bringing me back in. They will be very quick. Two very small supplementaries. Firstly, it's just two linked areas. I did say it when I finished my first round. I had two more. Firstly, relating to your answers to Jackie Bailey, you very helpfully, I think, set out for us that legal advice is never binary. It's not you're going to win or you're going to lose. It's a balance of probabilities. It's the yes, you've got an arguable case, but here are the chances of success, and it's fluid. And that those chances of success will diminish as this happens from time to time. And there's a tipping point. There's a point at which legal counsel will tell the client, and not just talking about this, but generally, listen, the chances of success are so small now, it's not worth going on. And I'm sure every client in history wants to believe they can still win. And they will cling on to that hope. And they may do so to the point where their counsel threatens to resign because they're not being listened to. Does that happen generally, would you imagine?
I wouldn't have said it would happen generally.
Yeah.
I mean,
well, okay, let me be specific.
No,
did it happen in this case?
The scenario, no, I can't comment on what this case. Okay. But the scenario that prospects change over time is a common feature of litigation.
But you can see a scenario where I'm getting at where
yes,
the Permanent Secretary, other government officials were so keen to press on with the glimmer of hope that legal counsel might have threatened to resign had they not heeded that advice about the diminished chances of success. It's a rhetorical question. Final question. On paragraph 10, convener, if I may, paragraph 10 is still active. We've been told that. There's no amending guidance behind it. Yeah. Do you feel, A, that exposes the government to further legal risk, and B, that it might prevent other people coming forward to raise complaints about former ministers under this procedure?
It's still extant and it's unchanged just now. I actually, as I answered or tried to answer to Alison Johnson, I don't think the wording in itself is necessarily wrong in all circumstances. If anybody were to come forward now, obviously we've learned in the practical operation that we wouldn't allow the situation to arise as arose in this particular case. And so although the wording might not have changed, again, referencing the fact it was a combination of the wording plus the facts led to the difficulty in this particular case, then I don't think the policy is necessarily inoperable. Your second question was a slightly different one, and I can see the point you're making, that it could be a situation where people are discouraged from coming forward because of the past experience that would arise. I don't think a change of the wording would in itself solve that, but it's obviously a very legitimate point. In trying to encourage people to have the confidence to come forward, it's important that there's a procedure that people have confidence and trust, and that's what's being reviewed by the government. Because
the judicial review collapsed 2 years ago.
Yeah.
And in those 2 years, not one single thing has changed about that policy. If you're in a position where you've been thinking about what happened to you in a historic context by a former minister, why on earth would you put yourself through that, given that nothing's been done to remedy that flawed procedure? Yeah. It's a rhetorical question.
It's a rhetorical question, but it flags up just how difficult it is for people who have these concerns and have been the subject of harassment in the past, to have the confidence to come forward and have those properly concerned, they're properly investigated, and that's seen, across the world. And in that sense, it's obviously right to flag up that anything that discourages people to have the confidence that they will come forward and be believed and be investigated properly is something that none of us want that situation to be in place, and we all want a situation where people, men and women who could have been in that situation, could have the confidence to come forward and have their complaints investigated properly and thoroughly.
Thank you, Convener.
Thank you. We'll see if Jackie Bailey understands the concept of quick.
Very quick, and my apologies for having missed this. Were external counsel asked for an opinion on paragraph 10 and what it meant for the prospects of success, and when was that opinion sought?
They were throughout the process, but specifically when the issue arose, then the focus became in paragraph 10. So they weren't asked for an opinion prior, because none of us knew that was going to be an issue.
Could you tie down a date? I don't want to annoy the convener, but I'm looking for a date.
I think probably the best thing to do, I think we can give, I think we can give an indication of when that issue came into focus. It's whether, I'm not sure about as to whether we asked them or they said to us or whatever. I'd need to go to look at the and ask colleagues to look at the background of that.
So it could have been that they said to you rather than you alerting them. It could have been on the 19th of October.
Well, again, it could have been.
Okay.
I wasn't at that meeting.
I look forward to hearing from you.
Okay, and finally from me, Mr Cackette, back to what seems like a long time ago now. In your first questioning, we talked about arbitration, and Alec Cole-Hamilton was very clear about showing the differences between arbitration and mediation.
Yes.
You talked around the decision not to go to arbitration.
Yes.
Some element of that being the potential effect it would have on the complainants.
Yes.
I would like you to summarise that, but also could you refer to mediation? Is that a decision that you were involved in?
I wasn't involved in the decision of the mediation. I mean, my understanding was that the suggestion of mediation was put to the complainers, and they rejected that. My understanding was that the arbitration wasn't, not to my knowledge, arbitration wasn't put to them, and I can only presume that was because, having rejected mediation, there was obviously a sensitive relationship of constantly going back to the complainers and saying, well, you know, have you thought about X? And if you don't like X, you thought about Y. So they didn't do that. I mean, I think the key thing, I think, in terms of mediation and arbitration and the court system, is that there are I maintain my answer about the inappropriateness of arbitration to claims of harassment or sexual harassment, but it's also true, and in one sense truer, of mediation. Because if this was a means by which the matter could be resolved in a way that could have avoided court proceedings and could have been agreed by the parties, mediation doesn't really do that. And what I mean by that is it's like there's a sort of matrix of decision making and dispute resolution. So the courts are mandatory. You can't avoid going to court if you're taken to court, and the outcome is binding. Arbitration is voluntary, but the outcome is binding. Mediation is voluntary, but the outcome is non-binding. So to go down the mediation track would have led to a risk that either party, if they didn't like the way the mediation was going, could have said, I'm not doing this anymore. And so as a means of getting to quick resolution, had I been involved in suggestions of mediation, which I wasn't because it was before my time, had I been involved, I would have suggested not, because of the non-binding nature of it. So, so that's on the mediation aspect of things. It seemed to me, or it would seem to me, had I been involved at the time. But in any event, the complainants rejected that possibility.
Okay, thank you very much, Mr. Cackette. It's been an interesting session, and thank you for the discussion that we've had amongst us all. I think you've agreed to follow up certain things in writing, and we can liaise on that. So thank you again, and we'll now have a short break of a few minutes before we move on to the next.
Okay, thank you.